have this caveat that everything I'm saying today does not represent the Commission's position. This will be officially known probably around the date of 22nd of November. There will be lots of question marks in my presentation, you will see, and the reason is that really before the college formally makes a decision, we don't know what will be in this forthcoming proposal. But I think you can have a flavor already of what is on the table, what is considered as potential contents of this minimum harmonization directive. That I can tell already. We don't aim at doing more than that. The main objectives of the Commission's work on insolvency, but more specifically on preventive restructuring and second chance, are very much linked to a few points that the governor made previously, namely to reduce barriers to cross-border investment in Europe, so to increase investment opportunities and job opportunities, to reduce the number of unnecessary liquidations and save as many companies as possible, of course those which are viable and not the other ones. And finally, to reduce the cost and increase the opportunities for second chance for honest entrepreneurs. This is crucial if we really want an innovative economy, because entrepreneurs are those who are usually testing new ideas. These are a few quick facts about insolvencies in Europe. According to our estimations, there are about 600 insolvencies taking place daily in the EU, and at least 25% of these have a cross-border dimension. There are 1.7 million jobs which are lost due to liquidations in the member states, and it is currently impossible to restructure a group of companies which have a presence in more than 2 member states, and this is due to differences in national laws. Recovery rates, according to a World Bank study, which is very well known, are higher in restructurings than in liquidation. And what differences in national laws translate in are different levels of efficiency and also recovery rates. The context to the forthcoming proposal is the Commission recommendation of 2014, with which you may be already familiar. We are working on that basis, basically, and we are trying to see whether we can improve it. We can provide further efficiency elements which would strengthen the restructuring framework and the second chance framework. And we have also been looking at formal insolvency proceedings or liquidation proceedings and tried to see if there is any possibility of harmonizing a few elements to make this more efficient. I will come back to all these aspects. I will start with the first part of the recommendation and of the future proposal, which is preventive restructuring procedures. It is not a secret anymore that the reason why we focus on preventive restructurings is to also address the problem of MPLs, which was raised earlier by the governor. And when designing this procedure, while you will see that we have stopped at the level of high-level principles and only targeted rules were absolutely necessary, we have tried to make some very ambitious advancements in EU restructuring procedures. We will see how far we get in the proposal itself and then further in negotiations with legislators. A few efficiency elements, most of them have already been announced in the Commission recommendation of 2014, sorry. The first one is the possibility to have an early access to the procedure, so before the debtor is insolvent. We have maintained this principle that there should be a likelihood of insolvency in order to have access to restructuring procedures, and the reason is that we wanted such procedures to be notifiable under the insolvency regulation and to have circulation in the EU. The debtor should be in possession normally, should have the control of the day-to-day operations of the business, and a practitioner appointed by the court should not be necessary in every case. It should be appointed on a case-by-case basis, depending on the complexity of the case, on the complexity of the restructuring measures which are necessary in respect of a particular debtor. There should be a stay, a possibility for the debtor to obtain a temporary stay of individual enforcement actions of creditors in order to address the holdout problem. Of course, the stay comes with important consequences for creditors, which we have tried to limit in several ways. You will see there are several safeguards related to the stay, and the first, probably most important one, is the limited duration of the stay. On the experience of most recent reforms in the EU, we believe that a maximum of 4 months. Of course, member states can decide to have 2 months or 3 months, but as a general, the initial period of the stay at least should not be more than 4 months. And obviously, there should be possibilities to extend it, but it would be left to the decision of the member states whether to have such extension possibilities, how many. The only condition we will make would be to put a maximum cap, and we are still considering what that should be. In the recommendation, it was 12 months. There should also be a possibility for the stay to be lifted in several circumstances, most notably where a majority of creditors no longer support the negotiation, so it is clear that a restructuring plan will not have chances of being adopted. And there are some other circumstances where the stay could be lifted at the request of creditors. There are new elements which are considered in the forthcoming proposal and which were not there in the recommendation. And these are provisions on executory contracts and on the inapplicability of ipso facto clauses. I will not tell you more about this. You will see the proposal very shortly, and I'm sure we will have plenty of opportunities to discuss the details of the proposal. On the adoption of restructuring plans, there is also an element which we consider adding. Here I have to stop and make a little parenthesis, even though the time is running so fast. We have worked on the future proposal with a group of experts, and several of these new efficiency elements were actually recommended by this group of experts. Even the drafting has been fine-tuned in collaboration with them. So this is only to acknowledge that input and to thank again the people who have contributed to this. It is not an effort only of the Commission. So on the adoption of restructuring plans, you may see a new possibility for a court to confirm a plan despite the dissent of one or several classes of creditors. There will be obviously safeguards to ensure that that nobody loses out, and we will see exactly when the proposal comes out, whether we got the balance right, and we can further discuss afterwards how things can be improved. Encouraging new financing was already an element in the Commission recommendation. We are now thinking about extending that protection to interim finance, so finance which is necessary to keep the debtor going during restructuring negotiations. We know that in several member states, new financing is given priority ranking in subsequent insolvency proceedings. But this may be a good idea, but there are, serious doubts on our side that this should be a minimum standard. I have to make a little parenthesis again and to say that what we are aiming at is really minimum standards, so member states will be able to go beyond this and provide for example, more protection for new finance, more incentives for creditors or investors who take the risk of putting money in a company which is already in financial difficulties. Court involvement is important, even more so where restructuring plans involve an impact on creditors' rights, for example, where there is a stay of enforcement, where there is a sort of cramp down on certain dissenting creditors. The court supervision is crucial, and we believe in that. However, we do not believe that the court is necessary at every step of the procedure, and where that is not necessary, then we believe steps should be taken out of court in order to speed up the procedure and reduce the costs. There are several other efficiency elements which we have considered since the adoption of the recommendation, and one is the introduction of early warning tools. We know that about half of the member states have very efficient public-backed or public-sponsored early warning mechanism, and I think France is one of them. We would not be able to impose that in all member states where there are serious concerns about spending public money in such cases, but we will try to find a way of encouraging early warning without requesting member states to spend money if they don't have it, basically. So we will see if we can successfully make advancements in that regard. We also considered, this reminds me of a very recent case which I've read, which was forwarded to us by one of our experts about a French restructuring which went wrong because of shareholders' opposition. I don't know how things will evolve in the future, but perhaps this could help. We will perhaps we are considering the setting down a principle that shareholders should not be able to oppose a restructuring plan which can bring the company, the debtor, back to viability. There will be safeguards for shareholders, obviously, and member states will have flexibility in how exactly they should ensure that this principle is implemented. As I told you at the beginning, we are concerned about the length of procedures in some member states. In about 14 member states, procedures take 2 or more years, up to 4 basically, and our aim would be to reduce the length in all member states to below 2 years. That would be great. But we cannot do much in a first step. This is the first step that we are taking in harmonizing substantive insolvency. And so the main efficiency elements also, hearing what experts have told us about the need to ensure that the judges are better prepared to take quick and competent decisions on insolvency cases, and the need to have higher standards of professionalism of insolvency practitioners in all member states. We have tried thinking of a few principled rules which would guide member states towards taking measures, making such procedures more efficient and therefore, we hope, less lengthy. One important element also is a provision which we are considering on the digitization of restructuring and insolvency procedures, which is also hoped to reduce proceedings, but also increase the level of participation of creditors, especially those who have small amounts of debts or those who are in another member state than the member state where with jurisdiction. Finally, I will say a few words about second chance for entrepreneurs. It is also a concern of the Commission to not only help entrepreneurs obtain a second chance, have the possibility of starting a new business venture where they are likely to be more successful because of their past experience. But it is also a measure which is linked with the aim of reducing NPLs. We will not be covering with this second chance procedures consumers, I can safely say that. But of course, member states are encouraged to extend the same principles, the same rules that they apply to entrepreneurs, also to consumers. We will be fairly consistent with the recommendation on the second chance aspects. There will be limitations also which member states can make use of in cases of fraud, dishonesty, or where there is abusive or repeated access. Certain categories of debt could be excluded from discharge, and again here member states will be able to decide which these debts should be. I will go back to the previous slide just to say there are new ideas, and one of them is to consolidate the procedures where this is not already the case in the member states. I think in several it is already when entrepreneurs have both professional debts and personal debts. And there are further other smaller ideas on how to ensure an effective second chance.